We'll hear argument next in number 02102, John Geddes Lawrence and Tyrone Garner versus Texas. Mr. Smith.
Mr. Chief Justice, and may it please the Court, the state of Texas in this case claims the right to criminally punish any unmarried adult couple for engaging in any form of consensual sexual intimacy that the state happens to disapprove of. It further claims that there's no constitutional problem raised by a criminal statute that is directed not just at conduct, but at a particular group of people. A law that criminalizes forms of sexual intimacy only for same-sex couples and not for anyone else in the state who has had the right to make a free choice to engage in the identical conduct. Petitioners are two adults who were arrested in a private home and criminally convicted simply because they engaged in one of the forms of sexual intimacy that is on the banned list in the state of Texas for same-sex couples. They bring two constitutional claims to the Court today. First, among the fundamental rights that are implicit in our concept of ordered liberty must be the right of all adult couples, whether same-sex or not, to be free from unwarranted state intrusion into their personal decisions about their preferred forms of sexual expression. Second, there's no legitimate and rational justification under the Equal Protection Clause for a law that regulates forms of sexual intimacy that are permitted in the state only for same-sex couples, thereby creating a kind of second-class citizenship for that group of people.
On your substantive due process submission, Mr. Smith, certainly the kind of conduct we're talking about here has been banned for a long time. Now, you point to a trend in the other direction, which would be fine if you're talking about the Eighth Amendment. But I think our cases like Glucksberg say if you're talking about a right that is going to be sustained, it has to have been recognized for a long time, and that simply isn't so.
Well, the Court's cases, Mr. Chief Justice, say that history is a starting point, not the end point of the analysis. And I think that it's important to look at history as a whole. And one of the errors that I think that the Court made in Bowers v. Hardwick was only looking at the issue in terms of homosexual sodomy and not looking at the issue in general terms, which is the right of everyone to decide for themselves about consensual private sexual intimacy. If you look at the history as a whole, you find a much more complicated picture. First of all, you find that sodomy was regulated going back to the founding for everyone, and indeed the laws in the 19th century didn't focus on same-sex couples. They focused on particular non-procreative.
Well, you're getting to your equal protection argument now. Let's separate the two. The first is your fundamental right argument, which has nothing to do with equal protection.
Well, Your Honor,
so the same-sex, other-sex aspect doesn't come into it.
I think it does come into it because if you're going to suggest that the state of the law on the books in the 19th century is the touchstone, you have to take into account that in the 19th century, at least on the face of the law, married couples were regulated in terms of the forms of sexual intimacy that were permitted for them.
It may well be, but so were same-sex couples.
Indeed,
so
they all were.
The fact is same-sex couples could not perform this act lawfully. What more do you need than that? It was prohibited. When you go beyond that and say, but it was also prohibited for other sex couples, you're getting into an equal protection argument, it seems to me, not a fundamental right argument.
Well, I guess I'm suggesting, Justice Scalia, that it's been conceded here by this state, it was conceded by the state of Georgia 17 years ago, that married couples can't be regulated as a matter of substantive due process in their personal sexual expression in the home. That means that the state of the law on the books in the 19th century can't be the deciding factor.
They conceded it. I haven't conceded it.
Your Honor, that may well be true. I was working with the assumption that there may be justices who are of the view that married couples do have such a right, and I'm suggesting that the real issue here is whether that fundamental right extends outside of the marital context into other unmarried couples who form bonds and for whom sexual intimacy plays an equally important role in their lives.
But you were talking specifically about the Eisenstadt against Baird, where there was an unmarried couple. Well, there was an unmarried person, and the conduct in question would have been perhaps in the 19th century, early 19th century criminal. talking about fornication.
Yes, Justice Ginsburg. I think the court has moved from Griswold to Eisenstadt, has moved in the contraception area outside of the marital context to the unmarried context. Certainly the qualified right to abortion applies to unmarried people as well as married people. And I think that what the court, in looking at this issue of the scope of the fundamental right to make choices about sexual intimacy, ought to take into account not just the state of the law on the books in the 19th century, but a couple of other factors. One, the change in enforcement in the last 50 years, because the court's fundamental rights cases all do look at current law as well as 19th century law. And also, even in the 19th century, the fact that there's no record of active enforcement of these laws against conduct of adults consensual occurring in the private setting. And that's true for married couples. It's true for different sex couples who weren't married. It's true for same-sex couples. The enforcement of the sodomy laws of this country going back to the founding involves coercion, it involves children, it involves public activity. It doesn't involve the kind of conduct that's at issue here. So you really have a tradition of respect for the privacy of couples in their home going back to the founding. And I think then what began to happen in 1960 was a recognition that we should take that tradition and turn it into positive law on the books. And so you've now had 3/4 of the states who no longer regulate this conduct for anyone based on a recognition that it's not consistent with our basic American values about the relationship between the individual and the state.
Well, it depends on what you mean by our basic American values. To revert to what the Chief Justice was suggesting earlier, really what's at issue in this case is whether we're going to adhere to, in the first part of the case, not the equal protection aspect, it's whether we're going to adhere to what we said in Glucksberg, namely that before we find a substantive due process right, a fundamental liberty, we have to assure ourselves that that liberty was objectively, deeply rooted in this nation's history and tradition. That's what we said in Glucksberg, and we said it in other cases. Or we're going to depart from that and go to the approach that we've adopted with regard to the Eighth Amendment, which is that it evolves and changes in social values will justify a new perception of what is cruel and unusual punishment. Now, why should we slip into the second mode? I mean, suppose all the states had laws against flagpole sitting at one time. You know, there was a time when it was a popular thing and probably annoyed a lot of communities. And then almost all of them repeal those laws. Does that make flagpole sitting a fundamental right?
No, Your Honor, but the Court's decisions don't look just at history. They look at the function that a particular claimed freedom plays in the lives of real people. That's why contraception became an issue. That's why abortion
I don't know what you mean, the function it plays in the lives of real people.
Well, the Court has said
any law stops people from doing what they really want to do.
The Court has said that it's going to use reasoned judgment to identify a realm of personal liberty that involves matters that are central and core to how a person defines their own lives and relates to key other people. It's about moral upbringing of children in the home. It's about procreation or non-procreation in your sexual relations with your mate. It's about basic questions of what kind of a family you're going to live with and other intimate associations.
Well, you say it's about procreation or non-procreation. But none of the cases that you have talked about involved non-procreation, did they?
They certainly involve the right to decide to engage in sexual relations while preventing procreation. That's what Griswold and Eisenstadt and Carey all say you have a right to do. That there's a right to decide whether to bear and beget children, and that right resides with unmarried people as much as it resides with married people. And I submit to you that it's illogical, fundamentally illogical, to say that an unmarried couple has a right free of state intrusion to decide whether or not to have procreative sex or non-procreative sex, but doesn't have the right to be free from state intrusion, free from a law that says you can't have any sexual intimacy at all. There's a jagged piece missing from the edifice of this Court's substantive fundamental rights jurisprudence.
It doesn't say you can't have any sexual intimacy. It says you cannot have sexual intimacy with a person of the same sex.
Well, this particular law does that, yes, Your Honor, but certainly our submission is that fornication laws and laws involving sodomy regulation more broadly would be equally unconstitutional because they involve.
But your position, as I understand it, is even if you take the narrowest view of Glucksberg, and even if you say there's got to be a positive historical sanction, that in fact there is no substantial historical evidence to the contrary, because A, the sodomy laws were not enforced against consensual activity historically, and B, they were not aimed at homosexual as opposed to sodomy in general. Is that your historical point? You say, even if I accept your argument, I should win?
Yes, Your Honor. I think, first of all, that the positive law, the law in the books, proves too much because it intruded right into the marital bedroom, and that the record of enforcement, which may be more informative, actually supports us rather than supporting the notion that this is something that can be regulated.
What do you mean by the record of enforcement? That what happened in this case was an accidental intrusion of the police. They didn't come into the bedroom looking for people conducting illicit sexual relations. They were there for another reason and happened to discover these men in that conduct. What do you mean by lack of enforcement? That the police have not gone around knocking on bedroom doors to see if anyone — I mean, this is not the kind of a crime the police go around looking for, but do you have any evidence to show that when they found it being committed, they turned a blind eye to it and did not prosecute it?
The evidence we have is the absence of reported cases discussing arrests for that kind of conduct.
Well, that's because it's an act committed in private, and the police respect the privacy of one's home, of one's bedroom, and so they don't investigate and find it. It seems to me what you would need is evidence that when the police discovered this matter, they said, these are not laws that we enforce. I don't see any evidence of that sort.
Well, certainly it seems to us there's a significance to the fact that it has never been treated as, for example, drug use in the home has been treated. And people the police obviously do actively seek to infiltrate homes to find that kind of activity. It's been treated in a categorically different way. But perhaps I should turn —
Can you characterize it? I mean, the ACLU brief has a lot of evidence along this line. And it seemed to me they want to characterize it as saying that the history has gone exactly the opposite direction than what's been suggested. But if you go back to colonial times, really, the laws not only were different, but look at the prosecutions. And they did prosecute people for sex crimes, but they didn't prosecute people for same-sex crimes. And then if you go across the history, it's only recently that people have been prosecuted for same-sex crimes. But is that a fair characterization? What is the real record?
The argument about 19th century enforcement is that they didn't prosecute anyone for private and consensual crimes involving adults, that they worried about children, they worried about public activity, they worried about coercion, but that they didn't worry about same-sex or different-sex sodomy. Now, as to the equal protection point, which I think I should get to in my remaining time, this is a statute which, in addition to intruding into that area of important fundamental protections, limits its focus just to one small minority of the people of the state of Texas. It says that these specified forms of sexual intimacy called deviant sexual intercourse are illegal only for same-sex couples and not for anyone else in the state of Texas.
What about a statute that covered both?
Well, I think that would be unconstitutional under my first point, Your Honor. Right. I think this is a multiply unconstitutional statute because it does the second thing as well. It says that — If the statute covered both, would there be an equal protection argument? If there was a record of enforcement almost exclusively as to same-sex couples, I think there would be potential constitutional problems there. But the statutory language itself would not involve an equal protection problem of the same sort that we're dealing with here.
Mr. Smith, aren't there a lot of statutes like that? Aren't there statutes in many states about adultery that don't cover sexual relations of one of the married couple with someone else of the same sex? Are they unconstitutional because of denial of equal protection?
I don't know whether statutes actually are written that way, Your Honor. The point I would make is that when a statute — What about rape laws? There are rape laws that only apply to male-female rape. That may be as well. I think
you think that they're unconstitutional?
I didn't suggest that they're unconstitutional. My point is that when a statute is limited to one particular group of people, particularly a minority of people in the state, that limitation itself has to be justified under equal protection, that that's a classification of people, not merely a definition of conduct, and that the justification of the line that was drawn here is insufficient as a matter of mere rational basis analysis.
I don't understand that. Why? suppose a state has a rape law that, requires penetration of the female sex organ which is, the classic common law definition of rape, and it has no law about homosexual rape. You think that law would be unconstitutional?